Okay, our next case is Davis versus Bruce Haspty, I guess. Okay, yes.
Good afternoon. May it please the court. My name is Douglas Dykes. I'm here on behalf of the estate of Pamela Denise Davis, representing the plaintiff below. If I could reserve 6 minutes, because there's going to be two issues addressed by opposing counsel, so I'd have 6 to come back. As indicated in the briefs, the issue, as I see it, is primarily one of proximate causation and whether or not the factual pattern we have in this case with a vehicular chase by a merchant who had just had something stolen from him, could that be foreseeable by the person that steals the property? This resulted in the chase, and the chase resulted in a wreck, and my client was the lead car at a red light, and whenever the chase car hit the car that had stolen the gas, the car that stole the gas hit my client's car. Because the car that had stolen the gas did not hit my client's car prior to getting hit by the chase car, the defense suggested to the trial court, and the trial court ultimately agreed, that there is no, shall we say, proximate causation, because there wasn't connection between the actual car that stole the gas and my client's car until it got hit by the chase car. The way that you reach that conclusion is you have to conclude that what the chase car did was so, I believe the terminology used by McCain and the other opinions is freakish, improbable, bizarre, so that it's otherwise unforeseeable that this could happen. The position of the plaintiff is that property rights are something that we all value in this country, and the property rights start at whether it's $1 in value or $1,000 in value. And
what exactly were the torts that Gregory Carter committed?
Arguably he drove negligently, based on the affidavit of Angela Carpenter, which is in the record. His driving down the highway, changing in and out of the lanes, never stopping whenever he was stopped initially by the people from the gas station that were basically saying, hey, you forgot to pay for your gas, you didn't pay for your gas. Continuing going down the highway, exposing all the other motorists on the highway to that type of...
So the tort is the alleged reckless driving on the highway as opposed to the stealing of gasoline?
Because the statute also required Mr. Carter to stay stopped at the gas station once he pumped the gas into his car. I think it started there with that behavior of driving off down the road. The testimony, I believe in the record, is that he spun out even at the time he left the gas station. It's the plaintiff's position to make his getaway, to flee the scene of where he just committed the crime, and continued south down Highway 77. Mr. Carter's testimony, as the court points out, was that he didn't drive wrongly. He didn't drive in a negligent fashion. That's not what Angela Carpenter says, who is a witness. And I would submit that on summary judgment, the standard is we have to believe Angela Carpenter. That benefits the non-moving party. Gregory Carter's testimony that he drove completely fine, was not in a hurry, was not trying to get anywhere, that should not be construed at all against the plaintiff at this point.
And as I understood your argument you're making, you're talking about proximate cause. I had really, as I read the briefs and the trial court's order, focused more on whether we had duty here, whether there was a foreseeable zone of risk created, so that the legal question, the question that courts can make and do make, is was there a foreseeable zone of risk created by Carter's action? And I know the trial court talked about legal cause versus, but it seemed to me that's really the issue here.
That's a very fair question. I believe that there were several duties that Mr. Carter, as another motorist on the road, owed to my client as a fellow motorist on the road that day whenever he pulled up behind her. He had a duty to operate his motor vehicle in a safe manner, and the careless driving statute goes on to say, with due concern for all attendant circumstances and conditions and situations. Mr. Carter knew that he had just stolen the gas. Mr. Carter knew that he was being pursued, and Mr. Carter failed to pull over and stop, and failed to stay stopped the first time the way he should have. He created, that's the statutory way you can get there, which I believe the McCain case or the Goldberg case points out, the 4 different ways you can create a duty. He either had the statutory duty, I contend, which is either careless driving, potentially aggressive careless driving, and or reckless driving. Again, I would refer the court to the affidavit of Angela Carpenter, which is she was beside him as they were driving down the road. Her testimony is very clear. The second way is just the pure zone of risk created by this type of behavior, that the law can recognize the duty as the potential risk of harm to others gets greater. In this situation, he had to realize, or I present as a matter of common sense, that if you're going to drive down a highway, and that would kind of lead over a little bit to the City of Pinellas Park case, which talks about chase cases from the police department standpoint, and they look at those factors that talk about, is it a highway? Is it a crowded highway? Is it a business street? Is it 4-lane? What time of day is it? And the more you do on the highway, we're not talking about a remote 2-lane road. This was a 4-lane major highway in Panama City. He was heading south about 12:30 in the middle of the day. There's businesses on either side of the road. You start to create an additional risk factor as you continue this driving pattern, this behavior. I think it was just a mere chance that at the exact moment that this happened, the red light happened to be red, and my client happened to be sitting there, again, innocent, completely unbeknownst to her. All this behind her is unfolding. Mr. Carter shouldn't have been driving past the point of, one, the Petro store. He shouldn't have been driving past the point that he got stopped by the people from the store saying, hey, you forgot to pay for the gas. And he shouldn't have been driving at the point whenever he got stopped behind my client's vehicle. His continuing to go continued that zone of risk going down the road.
So that is really what we're looking at, is continuing to operate the automobile.
I think that's part of it, especially with the knowledge that you're being pursued, which on summary judgment we have to give him that knowledge, because that's the affidavits of both the pursuers, Mr. Shaw and Mr. Patel, said they were banging on his window and told him basically, you forgot to pay for gas. And then Mr. Carter's own testimony in his deposition admits that as he's pulled off back down the road, continuing south, that he thinks that, well, it could have been the people from the store. Secondly to that, we would argue that the passenger in Mr. Carter's vehicle also should have had some knowledge, because there's an affidavit in there where it's indicated he went to the bathroom at the store where the gas was stolen in. The people that pursued him were in the store, at the counter, and the car they pursued him from came from the store. So for them all not to know or realize this is what's happening, I don't think that's at all feasible or plausible, especially on motion for summary judgment.
Well, what if a while after he recognized that he was being pursued, he had pulled over to the shoulder of the road to await his pursuers, and they had pulled over behind him and run into him there and forced his vehicle into some bystander or an automobile ahead? Would we have had a completely different situation there?
It's somewhat of a completely different situation. One, he has removed his vehicle from the roadway, which is what he was supposed to do. He was not supposed to be traveling in the first place.
You'd be here making the same argument, though, wouldn't you?
No, it would
that's
be
foreseeable, and it's generated by the fact that he left, and the fact that he pulls over. We all know that when people are being pursued, we have these excited situations, and automobile accidents tend to occur.
I believe so, but and I'm not going to argue against that situation. I think there would still be an argument if my client happened to be on the side of the road and they happened to pull him behind, and then the same crash happened. But again, I think that's different, because I think part of the reason this crash happened is because the excitement was still there, that they were still on the road, still arguably trying to get away, except for the fact that the light was red, and that they had nowhere else to go because the light was red. And in essence, my client was sitting there trapped, had no idea this was going on. The vehicle behind them was being pursued. And I wanted to point out one thing regarding the duty issue. I understand the duty issue, but I did not believe that that was the main issue before the court. I believe that the reason we got here is because the trial court incorrectly concluded that there was a break or an intervening cause on the foreseeability prong of proximate cause, which is clearly a question of fact, when she said that she found that the Carter vehicle had stopped and at that point in time then was hit by the Patel vehicle. Our position is that intervening cause is also a question of fact, and that ultimately what the trial court decided was the proximate cause, which is a question of fact, and then intervening cause, which is ordinarily a question of fact. And the only way that that should be taken from the jury is if, again, we go back to the bizarre, unusual, or extraordinary. And you don't have that in this case, especially when you have a statute passed by the legislature that allows owners of retail establishments to actually pursue and detain people that have committed theft from them until the police can arrive. In this case, I think his name is Mr. Behad Shaw, who was at the store, had actually called the police. The police were at the store with him, and while the police had just arrived at the store, then the deputies there, they received the phone call. There's just been this wreck down the road involving a car that fits the description of the one that stole the gas. So there's a very close connection, and to say there's an intervention just simply does not happen. We have a connection in time, we have a connection in location, we have a connection in parties, and we have a definite connection in the crash relation to what he did, all in violation of Florida law.
Mr. Banks, you're into your rebuttal time.
Thank you.
We'll reserve balance for you.
Thank you, Your Honor.
May it please the court, my name is Yates Romley, and I represent the appellee Gregory Carter. I'm about to lose my voice, so I apologize. I'll do the best that I can. I want to leave at least 5 minutes for Mr. Hires, who represents the other appellee, Cletus Carter. As I read the case law, and I agree, by the way, I think as I read the trial court's opinion that the trial judge was influenced primarily by the proximate cause issue. And as I read the cases on that, they say essentially that there is a proximate cause line out there somewhere. And on one side of that line, there are cases where the situation is sufficiently unusual that as a matter of law, a court decides that there is no proximate causal link. On the other side of that line, there's cases where the situation is sufficiently debatable that it needs to be decided as a fact issue by a trier of fact. And this line admittedly is skewed to one side. There's more fact issue cases on this side than there are question of law cases on the other side. But nevertheless, the question here is which side of that line does this case fall on? And I think as I read the cases where there has been a finding of no proximate cause as a matter of law, and I gave several examples of those in our brief, I believe this case falls on the side where it should be decided as a matter of law, that this was a sufficiently unusual situation, that there just simply is no proximate cause. And the first thing that causes me to believe that is the fact that what we're talking about here is such a petty crime. And such
well, what does it matter? Suppose he'd robbed a bank and been chased by a teller. Would you say we ought to rule differently based on the seriousness of the crime?
Well, I think at some point, I think it does make a difference. For example, if Gregory Carter had kidnapped A. Patel's wife from the Petro store, I think we might have a different situation. I think it would be maybe understandable that someone would drive recklessly trying to save their wife, but that somebody would drive crazily on the streets over $18 worth of gasoline is, to me, somewhat strange. And a lot has been said or has been made of the fact that in the process of driving between the Petro store and the point of the accident, there apparently was a time where Mr. Carter was, at least in the opinion of one witness, driving recklessly. But I don't see that as making any difference whatsoever, because the really important fact is that when this accident happened, he was at a stop at a traffic light behind another vehicle waiting for a green arrow. In essence...
But aren't you asking us to take one moment in time rather than the continuum of the entire action that occurred during the tort?
Well, I am, and I think that's pretty much what happens in most motor vehicle cases. And I'll give you, for an example, if I had been running late and driving recklessly to get to the courthouse this afternoon, and then somebody ran into my car while I was parked in the parking lot here, it would be interesting that I drove recklessly at some point before that accident happened, but it really doesn't have anything to do with what occurred at the time of the accident.
But isn't that very different than a chase in which Mr. Carter was an active participant?
But the bizarre part of this chase is that the behavior of these fellows in the chase car was so irrational and out of all proportion to what had occurred.
But why isn't that a jury issue?
Well, as I say, there's a line there. We've got to decide which case,
Right.
which side of the
You
line
just think
this
this
is
is
on.
so
But at
bizarre.
some point, it becomes unusual enough that it's decided as a matter of law. And for example, one of the cases that has been decided was this case where a hydraulic lift with forks on the back was left down on the back of a truck, and somebody ran into the back of it and got speared. To me, you could almost see that accident waiting to happen, but as a matter of law, there was no proximate cause. That was sufficiently unusual. There was these fellows who had no experience operating a backhoe, and they hotwire a backhoe to clear some trees after a hurricane, and sure enough, somebody gets hurt when this backhoe is being operated by a bunch of novices. Again, this seems to me like a situation where it was an obvious accident waiting to happen, but no proximate cause as a matter of law. I think this case fits into that really unusual category. You simply, if somebody told you that somebody took $18 worth of gas and somebody drove crazily down the road and ran into the back of them, killing a passenger in a car in front, you would say, holy cow, unbelievable.
The facts are, though, that he knew they were after him. They stopped him once, and he drove off again. So even if accepting what your facts are, that he shouldn't have anticipated that they were going to come after him, he knew they were after him.
Well, but again, we have the fact in our case that he was at a stop waiting on a traffic light. The Florida Supreme Court, as a matter of fact, in the Clampett case, in the 5th DCA, and the Pierce case, has said that in that situation where a vehicle is properly stopped and struck from behind, there's negligence as a matter of law and no comparative negligence on the stopped vehicle driver as a matter of law. We sort of fit right into that situation. And again, that's the point I was making. The fact that back up the road, maybe according to one witness, Mr. Carter was driving in a reckless way is, interesting, but really sort of beside the point, because he wasn't driving improperly when the accident occurred. The only person driving improperly when the accident occurred were these two guys in the chase vehicle, who, by the way, the driver really had nothing whatsoever to do with this Petro store. He just happened to be in there at the time this occurred. And the passenger was nominally a secretary in the corporation because he had helped his friend set up the corporation before he came over from India, but had absolutely nothing to do with the operation of the store. So another bizarre circumstance that we have in this case that I think puts it over that line. So I believe that the trial court was correct, and that the summary judgment should be affirmed. And
Thank you, Mr. Rumley.
Afternoon, Your Honors. My name is David Hires, and I represent Cletus Carter, who is the owner of the vehicle that the son, Carter, was driving, the one that was stopped behind the plaintiff's vehicle and was struck from behind. There's two issues I'd like to present to the court. One is to address your questions on zone of risk, but the other one is unique to my client, and that's dangerous instrumentality. I want to touch upon that first because in reading the appellant's reply brief, he completely mischaracterized where I was going with it, which means to me that I didn't get my point across. So I want to see if I can get my point across better here today. First of all, we absolutely agree that the owner of the vehicle is liable under Florida's dangerous instrumentality doctrine for the negligent operation of the vehicle. And no, I am not arguing that the son was using the vehicle in any weapons-like manner or under any of the exceptions. Why I presented those cases was to show where the confines of dangerous instrumentality doctrine are. It's for the negligent operation of the vehicle.
Would you agree, Dan, if we were to reverse and send it back for a jury to find whether or not the son was negligent, then your client would also have to be reversed?
No.
Why not?
No. Dangerous, because the best analogy is that I am not arguing an exception to the hearsay rule here. I'm arguing that this is non-hearsay. I'm not arguing that this is an exception to the dangerous instrumentality doctrine. I'm saying it doesn't fall within the dangerous instrumentality doctrine. And here's why. When the accident occurred, the exact moment the accident occurred, the car is lawfully stopped at a red light waiting for the light to change. At that point in time, there's no negligent operation. So when the accident occurs there, the owner can't be liable, nor can the driver be liable at that point in time. Let's back it up to what you asked. We're now swerving a little bit, maybe going a little fast according to the affidavit of Carpenter. Then he stops and gets into the accident. Is there negligence there? If the Carter vehicle had hit the plaintiff's vehicle, yes, but it did not. It came to a lawful stop. It didn't slide and hit into it. So there's still no negligence that caused the accident. Why does the accident occur? The accident occurs because this vehicle is chasing it. Why is it chasing it? Not because the way it's driving. It's chasing it because it stole the gas. So to answer your question, Cletus Carter, the owner, is not liable for the gas theft any more than he'd be liable for a bank robbery or anything else. So if you decide, which we ask you not to, but if you want to look at the entire chain of events, which is what the plaintiff is arguing, that the theft of the $17.60 worth of gas set in motion an entire chain of events. If you look at that as being what caused this whole thing, dangerous instrumentality doesn't apply. Unless the Carter vehicle had hit somebody else, run somebody else off the road, which is not the fact pattern we have.
But Mr. Dyke's argument, as I understand it, is that the real negligence here was for the driver of the vehicle who had stolen the gasoline to continue to operate the car and drive it down the roadway when he knew he was being pursued. And that's the theory, that was the negligent operation that ultimately led to the unfortunate outcome.
Okay. I submit to you that when you look at his brief, that the first part, on the last page of his brief, he's talking about what commenced the whole thing was the theft of the gas. Let's just say there was a car chase, and he's driving the car, but then he has stopped. How is the owner of the vehicle liable when what is the precipitating factor here is the theft of the gas, and it is not the continuing operation of the vehicle which causes the accident?
Well, the owner of the vehicle under the dangerous instrumentality doctrine is liable for the negligent operation of the vehicle.
Absolutely.
And the plaintiff's theory is that whether he was swerving or driving too fast, simply the operation of that vehicle and moving it down the road to try to avoid apprehension by these pursuers was itself a negligent act. And I'm just having trouble distinguishing between the argument you're making now and the argument we heard from Mr. Rumley a minute ago.
The distinction I would make, Your Honor, is that it is the theft that prompted it. Had he been doing those actions absent the theft of the gas, we wouldn't be here, because that other vehicle would never be there.
Well, no, let's assume, change the facts. No theft of gas. These two cars were at a stoplight, and as young men are sometimes ought to do, they start jawing at each other from car to car, and a chase starts. And then the exact same thing happens. It seems to me we would have the same situation. The issue would be, do we look at the moment in time at the red light where Mr. Carter was stopped and not doing anything negligent and was hit? Or do we look at is it a snapshot or is it a video of what occurred the prior minute or minute and a half leading up to that collision. And I don't have an answer to that, but it seems to me, as Judge Polston said, if we agree with Mr. Gregory Carter's attorney that it's a snapshot, then your client is also
we are out
win.
also, yes.
But if we go with the video theory of the appellant, it seems to me you're caught up in that too. It seems to me, because then there would be facts that could tend to show negligence on the part of the driver, which would keep the dangerous instrumentality doctrine alive in the case, it seems to me.
My quick answer to that, Your Honor, is in this snapshot where he's sitting for about 30 seconds or so, if it was a sliding into it and they hit right afterwards, it would probably be a closer case. But in this situation where he stopped, 30 seconds in a traffic is an eternity. And I would submit that you could take that snapshot in this case. I've got 22 seconds. I want to hit zone of risk because I did that extensively in my brief as well. I would argue that there is not a zone of risk here for the stealing of the gas because it is not reasonably foreseeable. You have no case law that shows it ever happened, that there's been drive-offs. There's no legislation for drive-offs. The facts in this particular case show that it's unreasonable because the only two people who testified to it say they work gas stations, no drive-offs. There is no zone of risk. I commend page 299 of the Sierra case where they go through this. Thank you.
All right, thank you. Mr. Dykes, you have a little over 4 minutes remaining.
Thank you, Your Honor. Let me start, if the court would allow me, in reverse order. We should not accept the premise that he was lawfully stopped at the red light. Florida statute 812, as cited in my reply brief, clearly placed a duty on him not to operate his motor vehicle until he paid for the gasoline he had dispensed into it, clearly. So I can understand how we can have him 4 miles or 2 miles down the road at a red light and say he is then lawfully stopped.
Well, let me slightly change the facts. Let's assume he drives off without paying, gets down the road, and Mr. Patel and Mr. Shah follow him. He does not know he's being followed. There's no chase. He stops his car at the red light, and they run into him. Now, are you saying that simply because he drove off without paying for the gas and 5 minutes later was hit by people he did not even know were pursuing him, that there would be that we have a case that ought to go to the jury?
I don't think that violation alone, but I think that is part and parcel of what we have to look at when we go with the video theory, if you will, that the jury can certainly consider that hey, wait a minute, there is an instruction that he was at least supposed to say stop. So whenever they stand up and argue that he did get lawfully stopped, well, technically maybe he did, but then technically maybe he didn't because he never should have left to begin with. That's my argument. And then when you look at the rest of the facts that we have, as far as his driving pattern, as far as being stopped, continuing to go, the reckless driving pattern witnessed by Angela Carpenter, those things all combine to remove that premise of innocence that he's, quote, lawfully stopped. I think it's the overall picture. One brief comment on the video versus the snapshot. I would just invite the court, when you go back and you look at the Florida Supreme Court cases of Florida Power and Light versus Goldberg and the McCain decision, they all very much in these type cases take what I'm going to call the video approach because they start back in the Goldberg case and look at the power line went down and time passed, and then they determined the power line wasn't generalized, and then they had to turn off another parallel line and the red line went out. You always look at the overall context of how we got to the ultimate event. When you go back in the McCain decision, they talk about how there had been an area marked that was potentially supposed to be the safe area, and arguably he was inside the safe area, but they knew they had to mark it because power lines are dangerous. They always look at the video. You can't just suspend one moment in time and say, at that exact second. That is an argument that you can make, and certainly if that question of fact is decided in their favor, then the plaintiff would not have a case. What the plaintiff is asking for is the simple right that he has under Florida law to present his case to the jury. We're not saying we win hands down. They're the ones saying that we win hands down. We say it's a question of fact based on the substantial body of case law from the Florida Supreme Court and from this court. And one case I wanted to point out that was talked about in the brief is called LeMaster versus Glock. and I believe it's in my initial brief and or my reply brief, it says that the number of cases where the court can decide the issue of proximate cause as a matter of law are extremely limited. And I would submit under the facts that we have in this case, we do not fit into the category where it just happens that the forklift has the spear sticking out and the car pulls up and there's a wreck because the car's brakes weren't working properly. We have an active tortfeasor who's just committed a crime, who knows he's committed a crime, who knows he's being followed, who is trying to get away, and then after the crime tells one story that, oh, he didn't even stop at the gas station, and then his deposition tells a different story that says his goal was to go to his grandfather's house, get money, and go back and pay the teller. Completely different factual scenario regarding the activity of the tortfeasor. And if you think about the policy, which the only reason to excuse him for it being bizarre or unusual or unheard of is because as a policy of law, we just shouldn't hold him responsible because it just doesn't feel right. In this case, he is the reason this whole activity got started because of what he was doing, because he stole the gas, because he continued to go, and now we're going to excuse that behavior? That can't be the policy of law of the state of Florida.
Okay, thank you all.
Thank you very much.